12:30. Good afternoon, everyone. Thanks for joining us today. Our presentation today in this, I think, 12 series of Bressler's webinars is going to be regulatory and litigation issues registered investment advisors will confront on the heels of COVID-19. My name is Tanya Lambrechts. I'm an attorney at Bressler, Amory & Ross in Fort Lauderdale, Florida. And I'll be the moderator with our two panelists here, Kerry, Zinn, and Vivian Velasquez of V&V Consulting. I will allow them to introduce themselves in just a moment here, but I wanted to go over a couple housekeeping things. We're planning on making this presentation as interactive as possible. So we have here at the bottom, you'll see a number of different icons. The fifth icon here is a box that says chat if you hover your mouse over it. And that's the function that you guys can use on your end to ask us any questions at any time during the presentation. I'll keep my eye on it, and as questions come in, I'll present them to the presenters for commentary. So feel free to ask anything you'd like, and even if we pass the topic, I'm happy to revisit it when we can get back to it. We're also offering CFP credit and CLE credit today, so if you want credit for either of those, you're going to fill out the forms that were emailed to you prior to this webinar. If you have any difficulty or did not receive that email, just let me know and I'll be happy to provide those forms so you can get credit for it. So today we're going to actually focus on just 4 hot topics of the moment for RIAs. First being business continuity plans and mitigating regulatory risk in this environment. Second is ADV reporting of PPP loans and other material facts. Third, cybersecurity issues associated with work from home policies. And 4, regulatory and litigation risks associated with the market and the new normal. So before we jump into the topics, Kerry, Vivian, if you could provide some background about you to our audience, that would be great. Kerry, go ahead.
Sure, absolutely, Tanya. Obviously, my name is Kerry Zinn. I'm a principal with Bressler, Amory & Ross. I'm also located in the Fort Lauderdale office. My practice is regulatory focused with a significant amount of work relating to RIAs.
And good afternoon, I'm Vivian Velasquez. I'm the founder of V&V Consulting Group. We have been in business since 2012 and specialize in investment advisors and financial institutions that cater to international clients. And being based out of South Florida, we grapple with business continuity issues every hurricane season. So this is a topic I'm very familiar with.
So thanks, Vivian. We'll jump right into that topic. So business continuity plans, especially in this environment. I'll start with you, Kerry. What is a business continuity plan, and should RIAs have one?
Well, a business continuity plan is a plan that is reasonably designed to address operational risks and other risks in the event of a significant disruption. An example of a significant disruption is obviously what we're going through currently, which is COVID. It is mandatory under the Advisors Act for RIAs to have a written business continuity plan in place. There's no specific regulation dictating that. There was a proposed regulation in 2016 that was never implemented. However, like the SEC often does, they have backdoored the requirement based on 2 provisions of the Advisors Act. Advisors are required to have written policies and procedures reasonably designed to prevent, violations of the securities laws. And then obviously there is the fiduciary duty, and the SEC has stated that part of the fiduciary duty is the duty to protect clients from the risk of inability to provide advisory services. So on that basis, a written business continuity plan is absolutely required for registered investment advisors.
Okay, Vivian, do you typically advise your clients on the consulting side to create a business continuity plan, and are all business continuity plans the same?
So absolutely, firms should have a business continuity plan, and it should be customized to the firm's business. So for a larger firm, for example, that outsources to another country certain back office functions, there would be certain risk analysis and analysis of the risk and the capabilities if that country is faced with civil unrest or a pandemic and doesn't have the infrastructure to be able to continue to provide services. A firm with a trading desk would need to have processes and controls for the traders to be able to handle the volume remotely. A smaller firm would have the issue of whether or not they have decided to issue company equipment such as laptops and phones. So they would be relying on the individual employees to bring in the equipment, and then that company's grappling with making sure that there's security patches in place and the appropriate firewalls. So it should not be a one size fits all.
Okay, great. And you alluded to this in South Florida. We are very familiar with business continuity plans as it relates to hurricanes and natural disasters that come through here. But global pandemic, a health pandemic, is definitely a new one for us. And even more recently, we've seen some businesses have to close on a whim due to the protests. So Vivian, what should RIAs make sure they include in a current business continuity plan given these new circumstances?
So most firms do have business continuity plans. We did not have extended shelter-in-place type specific actions or considered a worldwide event such as what we have experienced. So the first thing I would say is addressing technology and the challenges of teleworking and focusing on access management and really getting an understanding of the type of data that's coming into the firm and out of the firm and the controls that can be put around it. So to the extent possible, making sure that there's restrictions on, for example, an employee's ability to print, an employee's ability to use USBs to then or cloud-based file sharing systems or other removable media to access proprietary information and sensitive client data. Then considering not just the laptop, but other devices. If the employees are using their cell phones, then having the ability to monitor if the equipment is lost, to be able to wipe the data for the smaller firms that like I just mentioned. I would say the feasibility of whether the firm is able to issue equipment going forward, and if not, offering the employees some sort of credit to make sure that the equipment that they have is a newer equipment. The older equipment doesn't really have all the firewalls and upgrades and technology. Then on the books and records and figuring out how to move from any manual processes to a more technology environment. So for example, if you're receiving checks, if you're dealing with manual signatures, medallion signatures, notarized documents, how to move that into a process where you're using cloud technology and digital capabilities to minimize manual processes, and then consider what new technology you're using, such as Zoom, WhatsApp, and how are you capturing that data to comply with books and records requirements. So another area, most firms have a succession plan that has focused on the principles of the firm, but really the firms need to think about key employees and key operation processes and making sure that staff is cross-trained and that there are procedures for certain key tasks in the event that certain staff becomes ill or unable to come into work. So that would be an expansion on succession plans. Also revisiting the starting plans, right? So we may be in this for the long run, so there should be a contingency for a prolonged period of starting and restarting. And finally, I would say also making sure that there's in place cybersecurity and business interruption policies.
Okay, all great advice. as we can see, there's a number of things that should be included in the business continuity plan in this circumstance that some people might not have thought of before this whole pandemic. Now, Kerry, do you have any advice to RIAs on what should be included in their BCP?
Yeah, I absolutely do. I think one of the most important things, particularly for the smaller to mid-size RIAs, is not to simply take a BCP off the internet, or not to take a consultant's, canned BCP. It's really critical that it be tailored to your specific business and the needs and operations of your business. It's pretty critical. And, as Vivian said, you have to include all sorts of possible scenarios. It's really important to sit down and brainstorm and think about, what else do we need to cover? A lot of them in the past have historically only covered natural disasters. Well, clearly now we know they need to cover pandemics as well. And it really is a brainstorming session to think about, what if there's a terrorist attack? What if there's infrastructure issues? What if the electrical grid's down for a few days? Really come up with this laundry list. And even if you don't think it's going to happen, include it and have a plan in place, because I don't think any of us really thought we would be in the midst of a pandemic. So it's best to plan for the unexpected. And one of the key areas, which I think a lot of RIAs overlook, is the fact that they should be looking at their vendors' BCP plans as well. It's critical that they do that they look at them, and typically a best practice is to require that the vendor test their BCP plan annually and give the results to the RIA. For the SSAE 16 certified vendors, ask for that report. That will provide insight on the operations and controls as well. And the bottom line is, you can't just have this plan, have it in writing, and stick it on the shelf and never look at it. You really don't want to try out your business continuity plan the first time you have to when something hits. You really should have in place annual testing, do mock significant disruptions, make sure your plan works so that you can identify, those mock disruption exercises will help you identify, any significant weaknesses that you can go ahead and address. And, training. It's important that employees know what they have to do under the circumstances of a BCP, because there can be sudden things that happen. Suddenly with COVID, all of us suddenly had to work at home. And it was a big change. And so it's really important to have these things in place, the policy procedures in place, but also to know through training and exercises, what you need to do when something sudden hits.
Great. We actually had a question come in, a very good question. I'm going to direct it to you, Vivian. It says, if using Zoom for staff meetings and client meetings, does this material need to be captured? And I'm assuming they mean with regard to books and records.
Right, that's correct. So that's one of the issues that we're grappling with working from home. And absolutely, if you're doing presentations, you should treat it as a public speaking engagement. So there should be an outline of what's going to be covered. And in a normal environment, you're not going to record every single conversation that an advisor has with a client necessarily, but you should have. If it's a Zoom call, if you're able to record it or at least capture what the interactions are, and that's really key during this process. Which is the most important thing is for advisors to be engaged with clients, and advisors have been engaged with clients and using technology to reach out to clients. Clients have been concerned and anxious everything that's going on in the market about the economy, understandably so, how that's going to impact their portfolio. So advisors have been using technology, WhatsApp, Zoom, but it's important that as firms start to use these new services, number one, they show that they've conducted due diligence on the providers and that they're making sure that their archiving requirements are being met to comply with Rule 1784.
Thanks, Vivian. So for the most part during this pandemic, businesses and consumers have been very understanding and lenient with a wide variety of things. For example, my car insurer is letting me pay 30 days later than usual. I've gotten a ton of emails stating and asking me to be patient because, a company doesn't have their full workforce available to them during this time. Are regulators in the financial industry expecting business as usual for RIAs in particular, or do you see some leniency by the regulators?
So
yeah, I'll direct that at you, Vivian. I'm sorry.
So what there has been some concessions, but for the most part, the regulators are expecting pretty much business as usual. The SEC and the state regulators relaxed a little bit the deadline for the annual updating amendment, and the SEC issued guidance on the custody rule that if a firm during the shutdown is not able to access mail, they relax the 3-day turnaround requirement. But having said that, we still have to, the industry has to meet regulation best interest and the Form CRS, which is due at the end of the month. And there's no reprieve for advisors from the requirement for the annual compliance review pursuant to Rule 20647.
And Kerry, I'm sorry, go ahead. Sorry. Cut you off.
For FINRA, FINRA has been a little bit more lenient actually than the SEC. They extended the deadline for the annual anti-money laundering audit to year end. So and that was due first quarter for the most part.
Okay, and Kerry, if an advisory firm is not acting as business as usual or not operating at full capacity, what could happen as far as the regulator point of view?
Well, if an advisor has an inability to provide advisory services and that negatively impacts clients, then there can be, risk, regulatory risk. The degree of risk depends on, the severity to which, the advisor was not able to provide services. And, it can range from examination findings on inadequate, policies and procedures, all the way to possible enforcement action. That's why it's critical to have reasonable policies and procedures in place, a reasonably designed BCP. This is going to be an area that is going to be scrutinized. We fully expect it to be. After Hurricane Sandy back in 2013, the SEC did a review and examined, business continuity issues. And I highly encourage everyone to look at the risk alert on that from August of 2013. It relates to a natural disaster, but there certainly are observations, and they identify weaknesses, what the SEC views as weaknesses in business continuity plans. And so, the industry's been on notice that there's certain things that they need to do. So to the extent that, if there's items that are in that risk alert that were not put in place, such as alternative locations, things like that, then that exponentially increases, the regulatory risk.
Okay, we had another question come in. I'm going to direct it at you, Kerry. Earlier, you spoke about the different scenarios that should be covered in a BCP, and a question from the audience was, does the BCP need to address each disruption individually, like a pandemic, snowstorm, power outage, or could the plan be more broad to address any kind of disruption?
That's a good question. What I would say to that is there's certain principles that would span across pretty much all types of significant disruptions. Things like ensuring that you have, ways to communicate with your clients, alternative locations, books and record, business continuity issues. So there's sort of these high level principles that are generic and will apply across the board, irrespective of what the significant disruptive event was. But that being said, there should be some tailoring that is done as well. For example, now that we've gone through a pandemic, it's probably a good idea, well, it is a good idea, if in your business continuity plan, you don't have, if you don't have anything with regard to basically almost your entire workforce, working from home, then that's something that should be added. So I think you can start with sort of the generic high-level principles, but then, maybe have subsets, of things that need to occur depending on whether it's a pandemic, it's a hurricane, it's a terrorist attack. That would be the approach that I would recommend.
Okay, and to close out the topic, Vivian, what should an RIA do today if they find that their BCP was inadequate in dealing with this COVID pandemic? Do you have any advice for advisors like that?
Yeah, so now is the opportunity to fix everything, to identify gaps and identify any flaws and how that can be fixed. Because we can be sure that the regulators are going to be looking and asking those questions. So now it's a good time to make an assessment. What worked, what didn't work, what could you do better, and then adjust as needed. And like Kerry said, a lot of the BCP plans in the past were geared towards the building will be inaccessible, or there's a hurricane, and then you're able to move staff temporarily to a location with power. Now this is a different situation that where we're looking at working from home and in an environment where the entire, not just one part of the country, but the entire country and world had to shut down. So I don't think that we had considered that, and now is the time to think about that.
Yeah, and I would just add to what Vivian's saying and say, if you had a material breakdown with regard to your BCP and a number of clients were impacted, it's critical that you document that issue and that you take prompt corrective action to mitigate the regulatory risk. And then depending on the degree and severity, if it's pretty severe impact on clients and they were unable, and you were unable to provide advisory services for a time period, that may be something that, obviously with the advice of counsel, you would want to consider perhaps self-reporting it to the regulator if it was, a systemic issue that resulted in significant impact to clients. But as always, it's important to document, and take corrective action promptly for any, weaknesses that are identified or any gaps.
Okay, thank you, Kerry and Vivian. I'm going to give the first CLE code right now. The code is tailored, TAILORED. You'll also find that in the meeting notes section at the far right icon at the bottom of your screen. So going on to the next big hot topic, there's been a lot of news about it, a lot of writing by industry professionals about this topic, A to V reporting of PPP loans and other material facts. So Vivian, I'll start with you. We've heard a lot about the government-backed funding available to businesses of all kinds during this time. Are RIAs able to receive funding from the Small Business Administration under the Payment Protection Program?
Yes, they are. And the issue for advisors is the requirement to disclose to clients if there are any going concern requirements that would impact their ability to deliver contracted services. A lot of advisors took the loan just as a cautionary measure to make sure that we didn't know when we first started with the process how long it was going to take, what the impact would be. So a lot of advisors that took this as a cautionary measure just to make sure that they had cash flow. It wasn't necessarily that from one day to the next they were unable to meet their contractual obligations. However, the SEC has said that advisors must disclose that they have received the loan.
Okay, and Kerry, there's just been a lot of debate in the industry of whether RIAs should be taking these loans. Do you have any commentary on that on both sides?
Yes, I certainly do. First of all, I'll just say it obviously depends on the unique facts and circumstances, but the certification for the loan that the borrowers have to sign states that the loan is necessary to support operations. And even though the guidance was a little bit all over the place, the guidance also stated from the SBA and Department of Treasury that you needed to evaluate whether or not you needed to take the loan and whether it was necessary to support operations based on the current business condition. So not some sort of future undetermined fear that you're going to need it at a later date. The guidance also stated that borrowers had to consider the ability to obtain liquidity from other sources first. The funds are primarily designed to be used for payroll in order to be forgiven. Like approximately 75% was designed to go to payroll. Other categories of acceptable uses were rent, utilities, mortgage interest. So there's a range of scenarios, right? At the one end of the spectrum, there's the clear-cut scenario where you have an RIA who, because of COVID, is about to eliminate jobs and cut pay. In that instance, that comports with the purpose of the PPP loan. If the RIA documents it and can substantiate that they were about to cut jobs and do a pay cut, then that's probably the best situation to be in to have accepted a PPP loan. In between there's a whole range of gray areas, and then you get at the other end of the spectrum, which is the situation where an advisor took the loan either because it was free money or due to some unsubstantiated future fear of advisory fees going down or whatnot. That becomes the riskier scenario. But ultimately, since this is a new reg, we're going to have to see, how the government approaches in what their perspective is. But, the safest bet is if the RIA needed, the money so that they didn't, for payroll, so that they didn't have to eliminate jobs and pay cuts. But again, there's multiple scenarios. It always turns on, the facts and circumstances. But ultimately, one of the things, Tanya, that you and I have done and put out there was an article, in FA Magazine and the Alert, in which we listed the criteria that RIAs should consider in determining whether or not to return the funds. If there was no good reason to take the money, then you might want to consider returning the funds, given the fact that there could be regulatory risk, and in addition, there could be reputation risk, particularly if you're a larger RIA and it gets publicly reported that you took the loan and didn't need it. We saw that happen with other types of businesses and industries. And there's the disclosure issue with the clients, and so forth. So there's a lot of negatives if you took the loan and you really didn't need it. And, the government has said, the Department of Treasury and SBA has said they're going to audit, businesses that took $2 million or more, and then spot check below $2 million. But I don't want anybody thinking that you're safe then from scrutiny from the government for having taken the PPP loan. I believe that this is an issue that the SEC will bake into their, examinations, and ultimately it's not a securities law violation. But I would fully expect them to, if they see egregious violations, that they would refer them over to SBA and Department of Treasury to audit and review. So, I think careful consideration needs to go into having accepted a PPP loan, and that you have a good reason to have accepted it, consistent with the purpose of it, and have it fully documented.
Okay, and so Vivian alluded, Kerry, this is for you. Vivian alluded earlier that there would be some sort of ADV disclosure if an RIA did ultimately decide to take the loan proceeds. Can you tell us a little bit about the SEC guidance out there on that subject?
Sure. In April, the SEC, issued some guidance on that. And, as we all know on this call, investment advisors, are required to fully and fairly disclose material facts, that impact the advisory relationship. The SEC reiterated that point and about PPP loans, but they only gave 2 examples of when the SEC thought it would need to be reported, and they were examples. Essentially, the SEC said, the guidance said, if the money is being used to pay, advisory personnel, that's a material fact. Or if the money is being used to live up to commitments, to fulfill commitments to clients, then that's a material fact. But, I can tell you, we've talked about this a lot in our RIA practice, and, about reportability, not reportability. From my perspective, given the fact that the certification was, the RIAs would have had to certify that it was necessary to support operations, I can see very few scenarios in which acceptance of the PPP loans would not be disclosable. Because the fact of the matter is, if you're certifying that it's necessary to continue operation, to support operations, you're essentially saying, but for the loan, you wouldn't be able to support your operations. And that really goes to the heart of, one of the Form ADV categories, which is you need to disclose financial condition reasonably likely to impair the ability to meet commitments to clients. So I think there's very few scenarios in which it would not be reportable. And, given, the uncertainty and the current conditions, from my perspective, it's material enough, particularly any sort of issues with financial conditions due to COVID that could impair, ability to meet commitments to clients, that it's an issue that should be disclosed other than during an annual amendment. You shouldn't wait for the annual amendment if you're suffering, financial consequences from COVID, which could impact, your ability to serve your clients.
Okay, and Vivian, has the SEC opined on what exactly the disclosure should say or what it should include? I've seen a wide variety of different types of disclosures that RIAs have made to date, and they seem to be all over the board on what they're including in that disclosure. Can you give us some information on what the SEC has said so far?
Yeah, I have seen the same thing as well, and the SEC really hasn't been specific as to how it should be disclosed, but so I've seen some firms say, in compliance with SEC guidance, we're disclosing that we took a loan. However, we didn't have any. There were no situations that impacted our ability to continue as a going concern. And other firms have just made the disclosure without adding anything one way or another. So it's really all over the place, and I'm sure the SEC is going to be reviewing and providing feedback, so we may hear more afterwards.
Yeah, I think it's critical, though. I think the SEC's perspective will be, and I think it may have been alluded to in the guidance, is the nature of the loan, right? That's PPP loan. The amount should be disclosed because that has a bearing on how material the loan is to the financial condition. And then also, as Vivian mentioned, the effect, work operations were ultimately not impaired due to loan, or if operations continue to, to be problematic despite the loan, then that should be disclosed as well.
And Kerry, what are the ramifications of an advisor who may determine that they don't need to disclose the loan or are not going to disclose the loan?
Well, the SEC takes very seriously when a material fact is not fully and fairly disclosed in the Form ADV, to investors. In particular, and one of the serious, non-disclosures would relate to the financial condition and whether or not it's impacting the ability of the investment advisor to, ultimately service the customer. So, I would expect at minimum examination findings all the way to, possible enforcement actions with regard to, failing to appropriately disclose the issue.
Okay, Vivian, I'm going to direct this question at you. It's a question I've gotten a few times from clients and people just generally, but some IARs brand themselves under trade names and corporate names and then took PPP loans under those corporate names. Does the RIA itself have to disclose the PPP loans taken by their investment advisor representatives?
So it's a fact-specific question, but I would say absolutely the RIA has a duty to supervise and to know. So they would, at a minimum, obtain from the advisors details of what their financial condition was, the amount of the loan, and the purpose, and then based on that information, determine whether any disclosures are required.
Kerry, we kind of focused on the PPP loan so far, but is there anything else that an advisor should look at right now during this situation that may be disclosable or material disclosure on their ADV?
Yeah, I would be particularly focused on financial condition and ability to operate. Certainly the PPP loans are one issue, but perhaps there's advisors out there who had other sources of liquidity and had to take on additional loans and perhaps are, struggling because of, COVID and so forth. So it's pretty much anything that, negatively would impact the advisor's ability and, to advise the client and the advisory relationship. If it's pretty significant and material, disclose it within 30 days. And if it's not that significant, you could probably hold off until the annual amendment. But, it's unusual times. So you really have to sit down and think about, what needs to be disclosed, what is material to my clients, with regard to COVID and my operations as an RIA. So I think it needs to be carefully evaluated in each fact and circumstance.
Okay. Vivian, just to close out the topic, for those that we have in our audience that are also registered with FINRA, has FINRA weighed in on the issue regarding U4 disclosure or anything like that?
So there's a question on the Form U4 that asks whether there has been a compromise with creditors. And FINRA issued guidance that receipt of the the PPP loan, even though the terms are that provided that all conditions are met, the loan is forgivable either in part or the entire loan, that would not be deemed a compromise with creditors to the extent that all the other terms of the loan are met. So that was deemed to be by FINRA as part of the original terms of the loan and not a disclosable event.
Okay, let's hop into our next issue, a very hot one for the SEC for many years, cybersecurity issues. And we just had a question pop in for Kerry. Kerry, do you believe that illness, disability of IARs or principals has to be disclosed, and how does that square with the ADA? Good question.
It's a good question. I'm going to answer that question generally because it would depend on the facts and circumstances. Obviously you're never going to want to disclose anything, that violates the ADA, but you would need to consider if it's going to materially impact the advisory business, say somebody stepping down or so forth, you would need to consider and evaluate it really carefully on whether to disclose it, and then very carefully disclose it because of the ADA issues. But I'm answering at high level and generally because that would be a very fact-specific case, but it's certainly something to consider if the advisory business is closing down because the principal's ill. You may probably disclose that there's issues with continued operations, but do it in a very delicate fashion, and certainly consult a lawyer so you do it in a very delicate fashion. Don't run afoul of the ADA.
Okay, thank you. Okay, so yes, let's hop into this cybersecurity. The SEC has been hot on this topic for years now. Can you give us just some background on what the SEC has said to date about cybersecurity issues in recent years? Kerry?
Sure, absolutely. So obviously everyone knows under Reg SP, investment advisors have an obligation to safeguard customer information. So flowing from that, from Reg SP and obviously their fiduciary duty, firms are required to have cybersecurity policies and procedures and programs in place. Over the last several years, the SEC has issued a lot of guidance in the form of various reports, OC risk alerts, and so forth about cybersecurity. It's a very important topic. There's been a few cases brought, but certainly to the extent when a regulator is issuing that much guidance, it means firms should put their radar up and make sure that they're being fully compliant, because typically, the regulators will issue guidance over time and then ultimately start, bring out the enforcement actions in order to make sure the guidance is being followed. I highly recommend that you look at the treasure trove of guidance that is available on the SEC website on cybersecurity. The most recent piece that they put out was in January of 2020. It's called Observations, Cybersecurity and Resiliency. It was OC who put it out. And essentially they laid out in a high level way the core requirements of a cybersecurity program to make sure that it's resilient. And I'm just going to list those off for you, although I highly encourage everyone to take a look at it as well. Cybersecurity has to have senior level engagement at firms. There should be risk assessments performed so that firms understand where their cybersecurity risk is and can put controls in to mitigate, prevent intrusions and mitigate that risk. Obviously, like anything else in this industry, there needs to be written policies and procedures. There needs to be testing and monitoring of cybersecurity controls. Is what the firms put in place, is it working? Monitor to see if there's any intrusions. And then importantly, they stated that firms need to continuously evaluate and adapt to change. So your cybersecurity program should not be static. The people who commit cybercrime, they can be very creative, and just like any sort of criminal activity or fraudulent activity, they change their ways and methodologies and often come up with new ways to accomplish their goals. So firms need to be mindful to be focusing on those issues over time and adjusting their cybersecurity program and policies and procedures, to address new emerging ways to breach, systems. And then also importantly, there needs to be a communication plan, internal and external, so that when there is an intrusion or a cybersecurity event, it's communicated to senior levels, it's communicated to the people who need to take action and do things with regard to that event. And then ultimately also, there needs to be a whole plan for communicating to impacted customers. In this area, it is also really important to make sure that not only do you have your cybersecurity policies and procedure in place and all your ducks in a row, it's important that you're looking at your vendors as well. A lot of smaller mid-size RIAs often use vendors, for their platforms, and you should be conducting risk assessments of your vendor, conducting due diligence of your vendor's cybersecurity plan, and periodically assess it. Don't just do it once. Make sure over time, maybe once a year, you're checking with them and you're asking them to confirm that all their controls are in place, et cetera. That's pretty important. And then ultimately, you also need to consider in this space state law. There's a variety of, it varies across the states, but a lot of the states have information protection acts. And as a result, if there's an intrusion, in many states, you're required to report it to the state authorities. And there's specific statutes, depending on the degree of the breach, which require notification to impacted clients. And ultimately, if you don't follow the requirements, I've even seen some states have daily fines if you fail to follow the requirements of their Information Protection Act. So just be mindful of the fact that, yes, you need to have your cybersecurity program in place pursuant to industry regulations, but you definitely need to be mindful of the fact of the Information Protection Act. So really, when you have an intrusion and client-sensitive information is taken, like Social Security, things like that, the states also define differently what's sensitive. You really need to take a look at the state statutes, take a look where your impacted customers were, so that you're complying with each of the state's regulations that are applicable.
So Vivian, given the pandemic and everything going on right now, and all people's entire workforce being at home, do you think regulators are going to focus even more on cybersecurity policies and procedures today or in the near future than they have maybe even in past years?
I believe so. I believe that the second half of the year, we're going to see the exams ramping up. The only good news is that the regulators have indicated that going forward, they're going to be focused more on the remote exams. But so that makes it easier not to have someone sitting inside someone's office. That's really disruptive. But the flip side of that is that the request lists tend to be really lengthy and detailed. So it's less having someone in front of you that you have to deal with for a week or whatever time, but it's a longer process when you're having to write written responses and produce lengthy amounts of documents.
And so, Kerry, I've heard from RIAs that it took them, especially the smaller ones who weren't set up from home originally, it took them a few weeks to get set up at home in order to complete their job, and they were coming into the office probably when they shouldn't have. If RIAs have determined today that their cybersecurity policy isn't adequate, what should they be doing so that when a regulator comes by in an exam in a few months, they are in the best position they can be in?
Well, Like anything else, they should promptly correct it, particularly because we are still in the midst of the pandemic. And I think, a lot of professional health experts are expecting a second wave. So if there's any gaps or weaknesses, or perhaps there's cybersecurity policy didn't even address working from home, then that should be promptly addressed, documented, and remediated so that they're in the best position possible, in the event of regulatory scrutiny, either through examination or whatnot. There's a significant amount of risk with regard to intrusions and customer confidential information being taken. So it's critical that these policies are comprehensive and fully implemented and address all the scenarios that they need to. I suspect a lot of advisors are going to have to update with regard to the work from home. But ultimately, there's the regulatory risk. But you got to be mindful of the fact, particularly for the larger firms, that there's other type of risk as well. Different industries who have had data breaches and customer confidential information leaked have not only been subject to sort of regulatory action, but there's been class actions, although those don't always prevail because they have an issue showing harm. But there's also shareholder derivative actions with publicly traded companies. So some of the larger RIAs need to be concerned about that. Because, for example, Yahoo got sued for multiple data breaches in a shareholder derivative action, and it settled for $29 million. So there's significant risk with regard to cybersecurity on the regulatory side and the litigation side.
All right, and to close out the topic, worst case scenario, an RIA experiences some sort of data breach. Kerry, do you have any advice on what first steps an RIA should do if they do experience or think they might even experience a data breach?
Well, typically, I think a lot of them are relying on outside vendors in some instances, the medium and small. Get help from experts to close the breach and address the issue. Get help immediately. Follow your cybersecurity plan. Ultimately, I would always recommend that you consult an attorney about the reporting requirements because the states have various statutory reporting requirements. And also, depending on the degree of severity, you would need to evaluate whether to self-report it, to the regulator. If it was a significant breach, a lot of client confidential information was accessed, or even a small amount is problematic, actually. That's something you want to consider self-reporting, but to certainly take swift and prompt corrective action to close any sort of issues, and intrusions.
Vivian, do you have anything to add to that? What would you recommend to your clients if they suffered a data breach?
I agree. I mean, I think the first step would be to engage counsel because the risk, regulatory, litigation, reputational risk is too great. And it should be a cohesive response of how you're going to communicate this, not just to the regulators, but to your clients, to your employees. And, now with social media, there's the reputational risk is really severe. And the other issue I would say is, read the procedures, right? Because the first thing the regulators are going to do is read your procedures. So make sure that everyone that's going to be involved has read the procedures, understands what was done, what wasn't done, and then what can be done to mitigate it. And then it's also time to engage as necessary IT consultants to help you remediate immediately, and that shows good faith.
Yeah, and in this area, like some of the other areas, you don't want to have to try out your cybersecurity procedures when you get an intrusion, right? You should be doing annual mock runs, staging it so that you can put your procedures, run it through the trials, identify if there's any gaps, and also sort of doing these mock scenarios where there's a cyber intrusion. It also helps train employees on exactly what they need to do, because oftentimes when there's an intrusion, the most important thing is timing and reacting and being able to get on top of it as quickly as possible. So again, this is not one of those policies and procedures that you just want to sit on the shelf and only dust off when you have an issue. You should be actually, practicing it on at least annually on an ongoing basis.
And Kerry, you've talked in a few instances now about testing procedures. Should RIAs be documenting what they're doing to test their procedures?
Yes, absolutely. One of the founded within the securities laws is the reasonableness standard, right? What is reasonable? So if there is a cyber intrusion, but the RIA had reasonable procedures in place, then they have the basis to argue that there wasn't a violation, even though an intrusion occurred, because hackers can be very creative and create new ways to infiltrate. It's really important, to have the procedures, but then if you show that you're testing those procedures and those procedures actually worked in your test and you identified weaknesses and remediated those weaknesses, it really puts you in a much stronger position when you come under regulatory scrutiny to be able to argue that, yes, there was an intrusion. However, I took all reasonable steps and, therefore complied with the requirements.
Okay, thank you. And I'll give the second CLE code right before we start our last topic. The code is TEST, and you can find it in the meeting notes on the far right icon. Again, TEST, T-E-S-T. So for our final topic here, we're going to address regulatory and litigation risks associated with the market at this time and the new normal. We've had a few crazy months in the market, up, down. I mean, my portfolio was down 50%. Today it's up 5%. I don't even know anymore. So with the market volatility and unpredictability, what can advisors be doing now to limit their litigation and regulatory risks? And I'll start with you, Vivian. Do you have any advice to advisors in this market?
So continue with the suitability reviews and the basics, but just on an enhanced basis, right? So looking at suitability and looking at with everything that's going on with the market, making sure that because you have discretion, that your investment committee is thoroughly documenting all actions taken and what the reason for taking certain actions, and then looking at the client's investment policy statements and their suitability and risk profile and how that matches up. Also looking at are there concentrated positions, are there margin positions, looking at the type of investments that you see in this environment. So the new cure for COVID-19 or the new test, and those tend to be fraud. So being very mindful if a client has that idea to talk them out of it and do more research, staying away from penny stocks. Also, looking at large positions and then looking at an advisor's billing practices, whether or not you're allowed to bill, whether your policy is that it's disclosed that you bill on cash positions or you don't. So that could be an issue. And I would also say enhanced monitoring of employees, both their emails and their personal trading.
Okay, and Kerry, generally, given the pandemic, what can advisors be doing to limit their regulatory risk in this environment?
Well, there's a number of things they can be doing. First of all, as Vivian mentioned, these times of uncertainty and fear is when fraudsters come out and try and take advantage of people, and we've seen that happen. There's been a huge spike in phishing activities, where fraudsters send the email and they want somebody to click on the link so that they can then get access, to their system. I've heard of instances in which there's been some phishing where the email looks like it's coming from the RIA to one of the RIA employees saying, click this link and download this necessary software to work from home. There's other instances in which phishing is done and, the email says, click here for discounted masks or hand sanitizer. And there's even been phishing emails over toilet paper, if we remember the toilet paper shortage. So I think it's important for advisors to educate their staff and employees, about COVID specific, issues. Yeah, phishing always goes on. But, given the concerns about COVID, I could see where somebody could easily fall into the trap of clicking on that. The SEC has also come out and talked about, concerns about financial fraud, as Vivian, mentioned. They've indicated they're concerned about, stock promotions, market manipulation, fraudulent unregistered offerings, fraudsters using excuses like being a charity to support, medical treatments to draw investors in. And, there's also been fraudulent promotions of products, that represent that they're, a product with a fixed rate of high interest. We've seen that with regard to CDs. And there's even spoof websites where the CDs are offered. And so people are, as the market continues to have volatility, they're looking for somewhere to shelter their money, and not expose it to risk. And so I think RIAs need to they talk to their clients about their finances all the time. Some clients out there, particularly senior investors, may be susceptible to these types of scams. I would certainly encourage and say that, advisors should obviously try and talk the client out of it. But ultimately, if you see activity flowing through the account at a custodian, you're probably going to want to alert the custodian, because the custodian would typically have SAR filing obligations. Other things you can do, if a client gives you a PPM for a private offering, which is fraud, appears to be fraudulent, claiming to be for a company that has the next cure for COVID, consider passing that along to the SEC and reporting it, because unfortunately there are going to be a lot of investors that are going to be harmed, during these really, really uncertain times. The other thing that I would do ultimately is on cybersecurity, because of the second wave, and I think I mentioned this previously, there is the potential of a second wave that's going to be severe. We hope it doesn't happen. We don't want it to happen. Everybody's praying it doesn't happen, that we all end up having to shelter in place again. So at this point, I think it's critical, look at your cybersecurity policy with regard to work from home. Do you have to strengthen it? Do you have in your policy that employees need to work on a secured network that is password protected? Or better yet, require your employees to use a virtual private network to ensure, that the information stays confidential. Another thing that comes to mind, for example, is, most firms or, most employees are able to log into the firm's systems with Citrix. However, make sure you have in your policy that firm, that they are prohibited from storing, customer data, et cetera, locally on their storage. So I think those are some steps and things to be concerned about and to be able to address as we continue in these uncertain times.
We have just a couple topics I want to touch on here. First is customer complaints during this time. With the volatility in the market, a lot of investors are looking at their advisors to pin the blame on them. Vivian, do you have any advice for advisors who have customers who are threatening customer complaints or actually do bring a customer complaint because of their volatility in their account?
So now it's a good time to emphasize training and reminding advisors of the firm's policies regarding reporting of complaints and not attempting to resolve the complaint themselves. And escalating anything that looks like it could be a complaint, even though they don't believe it is a complaint, that the client is just concerned. It's better that it's handled by management, by compliance, than the advisor. And then also for advisors to document all their interactions with clients, what they're recommending, so the more they're able to, if there is a complaint and there is litigation, so what the attorneys want to see is that there is a trail of interactions where the client said, that there was no discussion, and the advisor is able to show contemporaneous notes of what was discussed. So I think that's really important to emphasize.
Yeah, and I think often it's the case that when there's an unreported complaint that hasn't been escalated up through management, it often comes in via email. So, it's a bit of a challenge for the smaller firms to identify and supervise the email. But, certainly, the medium to larger firms who are doing the email supervisory reviews should be extra mindful during these COVID times of ensuring that you're identifying, emails, complaints that came in but weren't reported up through management.
Okay, and then lastly, Kerry, if a firm gets a regulatory inquiry during this time or in the next few months, do you have any advice to them on how they should handle that regulatory inquiry?
It depends on the facts and circumstances of the inquiry, and it depends on the individual firm. Typically at the larger firms, they have an in-house counsel, or they hire counsel to address inquiries. Smaller firms, they tend to want to handle it themselves in some instances, or have a compliance consultant handle it. If it's a material issue that impacted your clients, then I would suggest consider hiring counsel to handle it from inception to the end, and be transparent, and just make sure if you have any get with the regulators with regard to any issues or gaps. That's always the best course. And certainly to the extent you have any, my advice is, before you get that inquiry, before the examiners show up, correct the issue, mitigate it, document you took corrective action. That can help you avoid potentially an enforcement action, or in the event that it's an issue in which they're going to proceed in an enforcement action anyways, it's a good mitigating factor to argue for lesser penalties. So, but just like anything else in this industry, document, document, document.
Okay, thank you, Kerry and Vivian. All the information you provided was so helpful. To the audience, next week we do have another webinar presentation by people other than us, and it's going to focus on the securities market, including the historical review of prior market disruptions, a current view of the COVID crash and rebounds, and a forecast for the future. So you'll get some information on that. If you're not part of our mailing list, feel free to reach out to me, and I'd be happy to include you on that so that you can be invited to the next seminar. Thank you everyone for your time, and I appreciate the audience for joining.
Thank you.